On November 22, 2022, Hans Niemann filed the amended complaint against all the defendants, including Hikaru Nakamura. And on December 7th, 2022, Hikaru Nakamura's lawyers filed a plea for dismissal of the complaint. Motion to dismiss was filed. So let me show you the motion to dismiss argument by Hikaru Nakamura and the memorandum in support for that. This is Hikaru Nakamura's motion to dismiss. The main part of the argument is right here. Plaintiff, which is Hans Niemann, a Connecticut citizen, has asserted various claims against, among others, Mr. Nakamura, a Florida citizen, relating to Mr. Nakamura's alleged expression of his opinions online while in Florida regarding whether others believed plaintiff, who has admitted to cheating at chess, cheated in a recent chess tournament. There is no basis, much less a basis sufficient to satisfy Missouri's long arm statute and the due process clause for the exercise of personal jurisdiction over Mr. Nakamura in this case. Moreover, and though the court need not reach this issue, plaintiff's claims against Mr. Nakamura also fail on the merits. So that's the two parts. First, that there is no basis for jurisdiction over Mr. Nakamura because Nakamura is a Florida citizen. The plaintiff was a Connecticut citizen, and the complaint was filed in Missouri, where the Sinfield Cup took place, where Carlson played. So there is no jurisdiction over Mr. Nakamura, who is a Florida citizen. That's the first part. Even if there was, the claims are actually false and they fail. That is their argument. Plaintiff Sherman Act claim fails for myriad reasons, including because plaintiff has not alleged an antitrust injury, does not allege an agreement among all of the defendants, and does not allege that any such agreement unreasonably restrained trade. So Sherman Act is a law which does not allow the business players to dominate the trade, which gives equal opportunities for everyone. It includes antitrust measures. So here there is no such proof, is what Nakamura is saying. Each of plaintiffs counts 1, which is slander, 2, libel, 4, state law tortious interference, and 5, state law civil conspiracy, is barred by Connecticut's anti-SLAPP statute. So, anti-SLAPP statute is a law which does not allow celebrities or people at the higher power to simply sue others who make a statement about them, unless there is proof of malicious intent. You can see here, further, plaintiff has not plausibly alleged actual malice. Actual malice means if the defendant actually knew that what he was saying is false and he still said it just to injure the complainant, then there is actual malice. You can also see here complaint from the basis of these claims, but regardless, statements of opinion and statements that plaintiff himself admits are true are non-actionable. So Nakamura's opinion, non-actionable. You can't sue him for that. And statements that plaintiff himself admits are also non-actionable. And there is no actual malice. Now, in the memorandum attached to this motion to dismiss, Hikaru Nakamura's lawyers explain each of these in detail. Let's go there. This is the memorandum in support. So this is a slightly detailed document. Whatever was explained in the main motion is here. Basically, the absence of any plated connection between Mr. Nakamura's alleged conduct and Missouri, much less one sufficient to confer this court with personal jurisdiction over Mr. Nakamura, is obvious. Plaintiff's claims against Mr. Nakamura must be dismissed for lack of personal jurisdiction. That is the main argument of Hikaru's lawyers. Simply put, all of plaintiff's claims pleaded against Mr. Nakamura are wholly defective. As such, they must be dismissed. So now the background. They basically mentioned what is the actual situation. On September 4, plaintiff alleges he won a chess game against Magnus Carlsen during the Sinfield Cup in St. Louis, Missouri. Plaintiff alleges that Mr. Carlsen falsely accused him of cheating afterwards, and when tournament officials refused his request that plaintiff be disqualified, Mr. Carlsen withdrew from the tournament. Days later, Mr. Carlsen refused to play a complete game with plaintiff in another chess tournament. Plaintiff admits to having cheated at chess before, but denies doing so during his Sinfield Cup game with Mr. Carlsen. None of these allegations relate to Mr. Nakamura. So why am I here? There is no connection between that and me, says Nakamura. Indeed, Mr. Nakamura is not mentioned until the fifth page of the amended complaint, and only sparsely thereafter. Plaintiff asserts that his relationship with Mr. Nakamura has been acrimonious for several years. They worked together in streaming, basically. Plaintiff takes issue with the online statements of Mr. Nakamura. Whether others believe plaintiff had cheated, whether plaintiff's pace of play and post-game explanation were odd, and publicly available news articles, and the 5 counts against the 5 defendants. Now, the argument is the main argument that there's no connection to Missouri here. The traditional jurisdiction analysis confirms the absence of personal jurisdiction over Mr. Nakamura. As such, each of plaintiff's counts against Nakamura must be dismissed. Now, they also fail to state a claim, each of these allegations. That is the next part. Standard of review. Plaintiff's counts 1 to 5 against Mr. Nakamura must be dismissed under Federal Rule of Civil Procedure for lack of personal jurisdiction. There's some technical things there. I'll link the document to the video so you can have a go through the whole document if you would like. So this is basically about jurisdiction, and that Missouri's long arm statute does not reach Mr. Nakamura in this case. There is not that much evidence connecting him to Missouri. The defendant must have set in motion some course of action which was deliberately designed to move into Missouri and injure the plaintiff. Only then there is a chance for the long arm statute to reach Nakamura. So that is the first part, the jurisdiction. Now the next part is they mentioned that the other counts fail for a lot of reasons. In his count 3, plaintiff alleges a violation of the Sherman Act. I already mentioned it's an act that allows fair trade for all business players. Mr. Nakamura highlights a case which the court may find instructive. Plaintiff allegations come nowhere close to stating a plausible claim. This is particularly true as to Mr. Nakamura, who is alleged to be a commentator in playing the game of chess. Plaintiff does not and cannot allege that Mr. Nakamura controls some undefined market in such a way that could cause an antitrust violation. So there is no breaking of Sherman law here, is what they're saying. And now the other counts to be dismissed based on anti-SLAPP law, which I already explained here. Now here, the lawyers actually mentioned the arguments that Hans's lawyers had formed. Hikaru's online statements. If plaintiff intended that each of Mr. Nakamura's alleged statements referenced at any point in the amended complaint forms the basis of his counts 1 to 2, which is libel and slander, defamation. Plaintiff still fails to state a claim to plausibly allege actual malice. Mr. Nakamura's alleged opinion that Mr. Carlson withdrew from the chess tournament because Mr. Carlson believed that plaintiff had cheated, and because plaintiff himself alleges, does not give rise to either claim, both because it is Mr. Nakamura's opinion and because plaintiff himself alleges that Mr. Carlson withdrew from the chess tournament because he believed plaintiff had cheated. So then there's nothing wrong with Nakamura saying that. And also it's his opinion. Likewise, Mr. Nakamura allegedly having heard that others believe plaintiff had cheated at chess is not an actionable statement. And plaintiff himself admits that he has cheated at chess before. Mr. Nakamura's alleged opinion that plaintiff's explanation as to how he beat Mr. Carlson and plaintiff's pace of play during the chess game were dubious. It's also a non-actionable opinion. That's his opinion. He has the right to do that. Mr. Nakamura's alleged retweeting of a tweet from Twitter from an account named Unsubstantiated Chess Rumors is not an actionable statement of fact. The Twitter account retweeted as was quite literally named Unsubstantiated Chess Rumors. That's funny. Mr. Nakamura's alleged belief that plaintiff attended the chess academy of Maxim Dlugy, who was rumored to have cheated in online games on chess.com, is likewise not an actionable statement of fact. Finally, Mr. Nakamura is not alleged to have published the articles or report on plaintiff's alleged cheating, but rather simply commented on them. That's also non-actionable. So based on all of this, the lawyers are asking for dismissal of the complaint against Nakamura. Seems fair, and I don't think this would go through, that the complaint against Nakamura would stay. The court should be able to dismiss this pretty easily, mainly because of jurisdiction and because Nakamura didn't have that much of a part in all of this. And you can see if the case is dismissed against Nakamura, then Nakamura will also be awarded his attorney's fees and costs. Or alternatively, this claim should be dismissed for failure to state a claim. So it will be a costly affair, the lawsuit for Hans Niemann.